Good morning, everyone. Today I will be presenting on the topic of remedies and damages for the CISG, with a focus on remedies available to both buyers and sellers. So my name is Mohammed Khan, and this presentation aims to provide a clear understanding of the CISG's provisions on this subject. What is the CISG? It's the United Nations Convention on Contracts for the International Sale of Goods, commonly known as the CISG. It governs international sales and contracts, and it aims to provide a uniform legal framework for the sale of goods between parties in different countries. And one of the critical aspects of the CISG is that it's designed to address situations where one party fails to fulfill their contractual obligations, ensuring that the injured party can be restored to the position that they would have been had the contract been performed as agreed. Now we can look, as you can see, specific performance for buyers, Article 46. This article is focused on the remedies available to buyers under the CISG. Article 46 grants buyers the right to require the seller to perform their contractual obligations. Under Section 1 of Article 46, the buyer can demand performances unless they have chosen an inconsistent remedy, such as contract avoidance. Section 2 of Article 46 allows buyers to demand substitute goods if the nonconformity constitutes a fundamental breach. Section 3 of Article 46 permits buyers to require the seller to remedy the lack of conformity by repair unless it is unreasonable considering all these circumstances. A notable case that I've mentioned here is the CTAC case 1994/10, where the buyer successfully demanded substitute goods due to nonconformity. Moving on to Article 49, which is the avoidance of contract for buyers. So Article 49 provides buyers with the right to avoid the contract if the seller's breach is fundamental. Section 1A of Article 49 declares that buyers can declare the contract avoided if the seller's failure to perform any obligations amounts to a fundamental breach. Section 1B of Article 49, however, allows buyers to avoid the contract in cases of non-delivery. If the seller fails to deliver within an additional period fixed by the buyer, this remedy releases both parties from their contractual obligations, except for damages. An example would be the Oberlandesgericht in München. This case was in Germany in 1995, where the court upheld the buyer's right to avoid the contract due to the seller's fundamental breach by delivering non-conforming goods. As we progress, we can move on to Article 50, which is the reduction of price for buyers. Article 50 enables buyers to reduce the price of goods proportionally if the delivered goods do not conform to the contract. This means the buyer can adjust the price to reflect the diminished value of the goods, of the non-conforming goods, without avoiding the contract. The reduction corresponds to the difference in value between goods as delivered and their value had they conformed to the contract. This remedy ensures that buyers are not overpaying for goods that they do not meet, the agreed specifications. A relevant case I could mention here would be the CTAC arbitration proceeding on October 29, 1996, where the buyer reduced the price due to nonconformity, and the arbitration tribunal supported the buyer's right. Next up, we cover Articles 74 to 77. So this is regarding the damages for buyers. These articles of the CISG outline the framework claiming damages due to breach of contract. Article 74 specifically provides for general damages, allowing buyers to claim for losses suffered due to the seller's breach, including loss of profit, as long as these losses were foreseeable at the time of the contract's conclusion. So next, Article 75 allows buyers to claim the difference between the contract price and the substitute goods. If they avoid the contract and purchase replacements, basically. Article 76 applies if the buyer does not purchase substitute goods, permitting them to claim the difference between the contract price and the current market price. Finally, Article 77 obliges buyers to mitigate their losses, reducing recoverable damages if they fail to take reasonable steps. And an illustrative case for this would be Delgy Carrier SPA versus Rotorex Corp, where the buyer was awarded damages for the seller's breach, including lost profits and additional costs incurred due to non-conforming goods. And next we can look at Article 62, which is a specific performance for sellers. Moving on to the available remedies for sellers. So Article 62 of the CISG will allow sellers to require buyers' performance. To require buyers to perform their obligations, such as paying the price or taking delivery of the goods. This remedy ensures that sellers can enforce the buyer's primary obligations and preserve their rights under the contract. Sellers can demand performance unless they have chosen an inconsistent remedy, such as contract avoidance, which we will get to in the next slide. This provision is crucial for maintaining the contract's integrity and ensuring sellers receive the agreed upon consideration. Another notable case was from Hamburg, Germany in 1996, mentioned here, where the court upheld the seller's right to demand payment from the buyer who had taken delivery but failed to pay eventually. So Article 64 allows it's based on the avoidance of the contract for sellers, as mentioned previously. Article 64 allows sellers to declare the contract avoided if the buyers failure to perform constitutes a fundamental breach. Specifically under Section A1 of Article 64, sellers may avoid the contract for any fundamental breach, such as non-payment or refusal to take delivery. Section B1 of Article 64 also permits avoidance if the buyer fails to perform within an additional period fixed by the seller. This remedy allows sellers to terminate the contract and seek alternative resolutions mitigating their losses. Another example would be the Oberlandesgericht in München, Germany, 1997, where the seller declared the contract avoided due to the buyer's failure to pay within the additional fixed period by the seller. So now looking at the resale of goods, Article 75. Article 75 provides sellers with the right to resell the goods if the contract is avoided and to claim the differences between the contract price and the resale price. This remedy helps sellers minimize their losses by quickly finding another buyer for the goods. If the resale price is lower than the original price, sellers can claim the shortfall as damages, along with also any further recoverable damages under Article 74. This ensures that sellers can effectively mitigate their financial impact. A relevant case in this situation would be Schroeder versus Salomon, where the seller resold the goods after the buyer's refusal to take delivery and successfully claimed claimed the difference in price as damages. Next up, damages for sellers, Article 74 to 77. These articles also apply to sellers here, allowing them to claim damages for losses resulting from the buyer's breach. Article 74 permits sellers to claim compensation for foreseeable losses, including lost profits. Article 76 allows sellers to claim the difference between the contract price and the current market price if they do not resell the goods. Article 77 mandates that sellers take reasonable measures to mitigate their losses. and failure to do so would be potentially reducing the recoverable damages. The comprehensive framework ensures that sellers are fairly compensated for breaches while encouraging practical and efficient resolutions. An illustrative case is the Tandrin Aviation Holdings Limited versus Aero Toy Store LLC, where the seller was awarded damages for the buyer's breach, emphasizing the foreseeability of losses and the seller's duty to mitigate. So, regarding the conclusion, the CISG provides a balanced and comprehensive framework for remedies and damages for both buyers and sellers. Its provisions ensure that parties are fairly compensated for breaches and encourage practical and efficient resolution of disputes. By understanding these remedies, parties in international sales and contracts can better navigate and enforce their agreements, promoting stability and fairness in global trade. So regarding the references and scholarly commentary, looking at the commentary on remedies and damages for the CISG for specific performance, Schlechtreim and Schwenzer highlight the importance of the principle of pacta sunt servanda, or agreements must be kept, which is reflected in the CISG's provisions. Honold emphasizes that specific performance preserves contracts and ensures that parties receive the goods as specified. Regarding avoidance of contract, Schlechtreim and Schwenzer note that its importance in protecting against significant breaches, while Honold underscores that it is reserved for substantial failures. For the reduction of price, Schlechtreim and Schwenzer stress its fairness in adjusting the contract price, and Honold finds it practical for minor breaches specifically. On damages, both scholarly commentaries mentioned here emphasize foreseeability and fairness with clear guidelines for calculating damages and the duty to mitigate losses. So that has been my presentation. Thank you everyone for your attention.